round of introductions. My name is Martin. I'm with a protocol called Q, like the letter Q. Website is q.org if you want to check it out. And what the protocol does, it provides a governance framework that other protocols can build on, can use, a really foundation layer for other companies, protocols, organizations to build on. Pass it over to Kyle.
I'm Kyle. I'm a legal engineer at LexDAO, one of the core contributors there. And legal engineers are people who are lawyers, practicing or non-practicing, and also who write code. So we automate the law with code as legalese, or code is law, code's law.
Very nice. My name is Jordan Teague. I am a legal engineer with Kyle at LexDAO. Also the general counsel of the Graph Foundation, if you're familiar with the Graph protocol. Also have a law firm called the Anti-Firm. We specialize in crypto native project legal advice. And maybe more relevant for this talk, one of the co-founders of Kali and Wrapper, which is a platform for DAOs.
So to get started, I will introduce a quick framework that helps you answer one question, which is whether your DAO needs a constitution. So we're really starting at the foundation layer, not assuming that you do, but really going into the depth of what is it that you want to do and what is a constitution for. Those who've been around in crypto blockchain for a while, you might have heard of a paper that was written in 2017, which was called "Do You Need a Blockchain?", which went through a process of asking 5, I think, or 6 questions and then coming up with answers to that question. So we're kind of doing a similar thing for DAO constitution, or trying to do that. I've developed the framework with my colleague and friend Garrett, so shout out to him, who can't make it today. He's has booth duty, but I'll walk you through it, and also really interested in getting feedback, either directly after this session or whenever you can get in touch. So as I said, 5 questions. The first one is very easy, and don't worry, I'll read it out to you. I'm not expecting you to read the small writing on the screen. First question is, does your DAO need to make decisions with a degree of discretion? Meaning that you have these decision types where some human input is needed. So basically anything that cannot be coded. And probably the answer for most DAOs is a very clear yes. Nevertheless, I would encourage everyone to think deeply about what the decision types are, because many things that I see that are in constitutions, can be coded. So things that can be coded should be coded. At least that's my view. But the discretionary types of decisions that cannot be coded, that might be a good starting point for a constitution. Secondly, how are those decisions made? Who makes them? And there are cases where basically you have a bunch of core people that just make the decisions on their own accord. If that is the case, there may not be much of a need for a constitution. But typically those decisions are made by the community, so you have things like decision rules, how are decisions made in terms of quorum, majority requirements, different levels of gravity of the decisions that have different decision rules. And if that is the case, a constitution, DAO constitution, is a good place to write down, to codify those types of rules. Thirdly, and I'm going to keep it short because Kyle is going to talk about that in more detail, the question is, can the scope of discretion of those decisions be defined? If the answer is no, that kind of makes it difficult. And we'll go into details of why that is so. But if the answer is yes, then you move on to the next question, which I think is one that's kind of tricky and one that many DAOs tend to get wrong or not think about sufficiently, which is there a mechanism to enforce DAO decisions? The reason being, rationale being, that if you have a constitution that lays down the rules, that's great. But if those rules cannot be enforced, the question is, what is the constitution worth? And of course, there can be an argument that it's a kind of a social contract between the participants. It's an implicit social agreement. If everyone agrees, if everyone's friendly with each other, that's great, that's fine, that's sufficient. But the very reason why you want a constitution in the first place is often that You want that for the bad times when people don't agree. You want to have guidelines that people can stick to, rules that people can stick to, and that they know what they're getting into when things are not in consensus, not in agreement. Enforcement of decisions is, in my view, a critical factor. It's tricky because how do you do that? There is no one single answer. It can be things like veto rights. It can be things like having to put up stake that can be slashed, and that leads to an enforcement of the decisions. It can also mean some kind of dispute resolution mechanism. It can even mean going back to, quote unquote, old world traditional legal systems to fight it out. Whatever it is, think about it. If decisions cannot be enforced, that makes it difficult, problematic, and potentially you're even worse off having a constitution because people rely on it and then find that they can't. Last question, and also that I will keep short because Jordan is going into much more detail on that, is does your DAO have a legal wrapper? And if it does, you should think about how that relates to the constitution, if legal documents are maybe even a constitution, and at the very least make sure that there is no conflict between what you have in the constitution and what's in the legal documents. And pretty much that's it. So 5 questions and you come out with an answer. It sounds simple. I know there is a lot of detail to go into on each of those. But if you've answered those questions, you might come up with the answer that yes, you need a constitution. And then it's about the details of how to construct it, how to draft it. And Carl's going to talk about one specific aspect of that.
Yeah, so these are decision types in DAO constitutions. Code is law, binary, really what we're talking about there in this discussion, compared to discretionary, which is more gradient, gray area. So yeah, so binary, and that's yes or no. So if you can have a decision for the DAO that's true or false, those types of left or right, that's a great thing for on-chain. And one of the values of it as well is that we can stack those decisions. So we can, especially with oracles, we can make them automated. So we can have 4 or 5 different decisions even lined up one after the other. But also, even if not, for instance, one they might not think about it as binary is, did we hold quorum or did we not hold quorum? And either we did or we didn't. And if it's on a DAO that has quorum, then on-chain it's going to tell us whether or not we have quorum, rather than in traditional organizations, people have to sign that they held quorum, and there's a certain level of trust that everyone in the room is telling the truth and such. And the discretionary is, yeah, more that we can't actually say, for instance, I don't know, what's your favorite color? I mean, we won't really decide that now, but we could, potentially. Green, blue, yellow, or something like that. And so on to next. So yeah, so I mentioned already that it's binary is automatable, and discretionary, it really isn't that automatable. Perhaps with AI we can get there a little bit, but still, we probably want to review that AI. So even then, when we can get computers to get more in the statistical methods, which they're doing very impressive work these days, we probably don't want to rely on major DAO decisions for with AI. And yeah, so we want to definitely, because discretion can go quite awry, give someone a lot of power. For instance, the whole benevolent dictator thing, hopefully they're benevolent. With Python, I guess that worked out. But still, why have that risk when you know that you don't want a certain amount of discretion already? Then it's important to narrow the scope. And that really is what the Constitution is supposed to do, for the most part, is to define where that scope is narrowed, and then also just say all this other stuff, we can do that binary, so it's going to be on-chain, have a look at that. And there's a clause that we use in LexDAO, I think it's fairly common now, which is, well, the concept is code deference, and then what it does is it points to a particular aux address, and that aux address is the source of truth. So yeah, so sometimes a really narrow scope, well, all else equal, if we know that we can have the scope as narrow as possible, then you have it narrow, and we can limit the harm caused by discretion, or even just straight up confusion. If people know the bounds of discretion, then they'll act within that a little bit better. And yeah, we want it to be as close as possible to binary. Hopefully, eventually, the discretionary decision will have a binary expression that we can then have fully on-chain. Broad scope, we still have to have it somewhat broad, especially when we want to work at the speed of business. So sometimes decisions have to be made in 1 or 2 days, and we don't have time to talk to the DAO, or perhaps we can't talk to the DAO for business reasons. A competitor could buy the Constitution out from under us, for instance. So one thing in DAOs, at least the DAOs I'm working on, where broad scope is pretty good, is to have a fund of like 1,000 or 2,000, something like that, to quickly do something like co-host a event at ETH Denver. That's something that happened in LexDAO actually directly. So we had someone say, hey, do you want to co-host? And it was around that amount, and you got a day to tell us. And so working on chain, code is law, that was just too slow. And so, but because we had this set up in our constitution, we could quickly make that decision. And then of course the DAO down the road can decide to either remove those members if they were making bad decisions like that, or keep them, give them a pat on the back and maybe a bonus or something like that. So basically, I mean, this is a concept in quite a few areas of life, but try to find the Goldilocks in discretion. So not too narrow, because otherwise your DAO members are going to be really restricted and nothing's going to happen, and everyone's going to get really frustrated because they spend a lot of time and stuff, and it doesn't get done. But also not too broad, because that's where we can have people take control of the DAO, and adversely even, if there's enough discretionary power, they can do that. So yeah, that's on to Jordan.
Awesome. So legal wrappers. You've decided that your DAO might need a legal wrapper, so we might need some sort of a written document. So legal wrappers is a topic that we could probably go into for hours on end in and of itself, and so we probably don't have time to get into that now, although I know there are a lot of crypto lawyers in the house who would be glad to geek out over that, including myself. Though I will give you one freebie, DAO LLCs, I don't feel like they're all they're cracked up to be. And if you want to read my opinion on that, I wrote an article in The Defiant, which you can look up as to why. But as Martin mentioned earlier, if you have a legal entity, oftentimes there are going to be legal documents like bylaws or an operating agreement, or in the case of, say, an unincorporated nonprofit association, some sort of a charter that you're already going to be drafting anyway. And so maybe this is actually where you memorialize all of these things that we're talking about, how the DAO is going to govern itself. Maybe you have a supplementary document, but you certainly want to make sure if you have multiple documents that they're not in conflict. And a word on that, I have seen a lot of constitutions, charters, operating agreements that do not defer to code, like Kyle mentioned. And you end up with situations like, for instance, the smart contract can't enforce a quorum, but the operating agreement requires it. That's insane. You don't want that situation. And so please make sure that if you want to defer to code on certain things, that you actually do that in your incorporation documents. But so if you're going to have a legal wrapper, or you want a constitution, okay, great. So now what? Where do you put it? How do you enter into it as a DAO? Obviously, a crypto-native way would be ideal, right? You might think maybe NFTs or putting it on IPFS where it's immutable. So wrapper, which we have a screenshot of on the screen, is one way that you can do this in a crypto-native way. This is at wrapper.wtf, so that's wrapper without an E, WRAPPR.WTF. And if you go onto Wrapper, this is the homepage, and the third option, Charter, will take you to a couple of pre-made templates. One is the LexPunks stateless charter, I think is what it's called, and then one by Orange DAO. These are great starting points. If you don't know what you want to include in your charter, these are great examples. But you can deploy a charter right here on chain. It'll be represented by an NFT that points to an IPFS file. So this is great because, first of all, it's immutable. No one can go change the rules of the game. They're right there. They'll never change. And second, you can send that NFT straight to your DAO smart contract if it supports NFTs, to a DAO wallet if that's how you're set up on something like, there's some DAO platforms that run on wallets, but in any case, you can send the NFT straight there, so there's no doubt this is the document that's attached to the DAO. And if you think of cases like UkiDAO, I'm not suggesting that this would have necessarily changed the outcome, but in the UkiDAO case, there was no charter, there was no private ordering. And you do have to wonder what might have happened if the CFTC had stumbled upon something like a stateless charter that said, we are not general partners, we are acting in our own interests. Maybe it would have moved the needle, maybe not. So Wrapper is a great way to do this in a crypto native way. And if you go to the next screen, you can also mint your own custom constitution, charter, whatever you want to call it. So if you come up with the rules of play and you want to mint them on chain, you can do it that way as well. Questions?
And we'll have more templates on the way, so check back in a month or two, and yeah, we're continuing to develop it out. Open law is a really important aspect of LexDAO's purpose, mission, what have you, so yeah.
Maybe just to add to that small commercial break here at this spot. So Wrapper, as of yesterday, is also available on the Q network. So you can come to q.org or look at the network, look at what it does, then go to Wrapper and mint your NFT legal entity actually on the Q network.
Any questions? Oh, yeah, absolutely. Well, so I think one of the big mistakes that I see is DAOs running off to exotic jurisdictions thinking that it's going to solve all of their problems. So there are some really interesting entity types like the Cayman Islands Foundation Company, and some of these other island jurisdictions that can work really well for decentralized organizations. But if you don't engage the right tax counsel, for instance, you might find out that that massive DAO treasury you have sitting in the Cayman Islands is actually controlled by a bunch of people sitting in the US and is subject to US tax. So that's just one small example of how, sometimes you can run off and do something that sounds like a good idea, but it's really not, which is why obviously engaging a lawyer sooner than later is always a good idea.
Another one I've seen is people don't follow the Constitution they actually implement. And perhaps they follow it initially, but then modus operandi naturally builds out. So it's not that they're doing anything wrong, but it's a good idea to, if you notice that there's behavior creep, that you revisit your Constitution and make sure that it's actually appropriate for the type of discretionary decisions you want to make. And then also you can also revisit and go, well, how many of these can we actually make binary? And again, sometimes it's not obvious if it's binary, like that you've met quorum. And then if it is, then perhaps build that out on chain if there isn't already a tool that can provide that.
One other note is, I think sometimes there's an assumption that these private ordering documents like a charter or a constitution will protect you from everything, and that's just simply not the case. I think they can do a good job helping to clarify issues among the parties, or maybe in the case of an operating agreement, they can help establish limited liability for breach of contract if you actually follow the formalities that are set up like Kyle mentioned. But they're not necessarily going to protect against all regulatory action or anything like that. So I think you just have to temper your expectations with what you're actually getting out of this. And there is a lot of value, but it's just not going to protect you from everything.
One small thing I would add is that there needs to be very close alignment between the legal side and the, let's call it operational side. So what I often see is that as soon as lawyers get involved, the people who are actually involved in the DAO, contributors, they kind of step back because they assume that legal will take care of everything. But actually making sure that you know what you want in the first place. What is it that you want to govern? I mean, that's really the foundational step. Without that, it's hard to take the second step. So also in discussions with legal counsels, and that should also always be the case.
Yeah, unless you're sizable enough to have a general counsel like the graph is with Jordan, the lawyers are going to leave after it's all set up, and then you're the one navigating that ship. So they're not going to help you navigate it. And if it's designed in a way that you can't do that well, then it's been poorly designed. And of course, you can modify the Constitution. Constitutions should be living documents. That was what I referenced that before. Another one a little bit tangential to Constitution, but still kind of important, is determining or having this on chain, or pardon me, just picking say an LLC through the wrapper service. That doesn't mean you're going to get a bank account. So you might have to do a lot of work to have the bank account, but in the meantime, you have contractually at least limited your liability, at the very least, between each other. You've agreed to indemnify and such.
So how do you guys see this playing out in like the next 5-10 years? Is there going to be big corporations using these wrappers, or is it more like the instance where you said, oh, I want to organize an event at ETH Denver and it kind of stays small? What's the ceiling for this, kind of these instruments?
Oh yeah, so this is more, okay, so corporations are going to do C Corp, and there are some organizations, one that recently released a product, firm.org, and that is focused on enterprise, and they're more on the way they're focused on enterprise. It makes sense where our market is. And then, small groups. We really enjoy Tuna, which is trustless, unincorporated nonprofit association. Are you trying to have profit? Then that might not. Obviously, it's got to be correct. But that one has very little reporting requirements, and so even if you're thinking about having a much more substantial organization, but you're just starting out, there's a handful of you have no idea if there's any traction or something like that, you can maybe think about your exploratory phase as don't even try to have profit, just have it be a lab. And then when you've kind of built that out, that you want to do this for the long haul, you can then, hopefully you've saved up some capital and then engage lawyers to have something that's more substantial. One thing that will benefit the overall industry is if we use these so they become standards. If there's only one or two random people here and there using them, then they're always going to be kind of exotic. But if for instance, A16Z is pushing the UNAs, the tunas, and they've spent a lot of energy figuring out how roadmaps on how to implement tunas and all that, and that's in part so that we, as a whole marketplace, have this as a very common standard, and the courts are much more likely to uphold it if it's something that is, say, a broad coalition is lobbying to have this more clearly accepted by compliance and regulators and such.
Have any of these made it to court yet? So you guys have these, you're expecting people to use them. Have they actually been battle tested and someone has gone to court and actually used these? Or we're still not there yet?
Yeah, great question. So I have a pretty extensive litigation background, and I can tell you it takes a long time for things to work their way through the courts. And so I would say the answer is, for a lot of this, especially when it comes to DAOs, no, there's really not a lot of precedent. But there is plenty of precedent that things like operating agreements and charters for UNAs have value. And so to answer you directly, no, not necessarily specifically with DAOs. So that remains to be seen.
Yeah, I would also add that even if those have not yet been battle tested, those structures, nevertheless, oftentimes you're better off having them than not having them, because also for DAOs it is true. What is a DAO? Has that been battle tested in courts? No. So having clarity around agreements between members and legal structure is probably a good idea.
And yeah, there's that contract liability. That wouldn't you say, Jordan, that since it's in contract, that particular subset of liability?
Yeah. Especially say if you're drafting an org doc for an LLC, it can be helpful if you're actually complying with corporate formalities and doing everything right, and you actually run your LLC properly. It can help you when it comes to things like contractual matters with third parties. So. And
in other countries, regulators work quite a bit with early markets. I believe Q has been spending quite a bit of time with regulators, and so there's a lot more confidence in those territories what's going to happen because there's been ongoing dialogue. In the US, we might be able to have legislation that then we can have certainty that way, and it doesn't have to go through the courts.
Any more questions? No, you've had 3. That's enough. You know. But okay, one more.
What is it backing up as, a class action lawsuit versus an SEC enforcement, or kind of how do these get looked at in front of the courts? How do they get there, and what do you want them for in those situations?
Sure. So it was a little hard to hear, but I think you said how do these make it to court? How do these get litigated, right? So, well, usually there has to be a dispute, right? So if you're talking about just a lawsuit between private parties, maybe the DAO has a contract with another DAO, or they've engaged a service provider, or they're providing services and someone's not happy, and so they file a lawsuit. If you're talking about regulatory enforcement, a regulator has to be unhappy with something and they file an enforcement action. So things don't just make it into court because reasons. There's this doctrine called standing, where there has to be an actual party with an actual problem actually about to suffer harm. Courts won't issue what we call advisory opinions. So you couldn't go into court and say, please bless this DAO constitution. You'd have to actually have some sort of a problem or dispute between parties or with a regulator.
Maybe I can add to that from the European perspective. So with the Q protocol, we have actually gone to the regulator in Liechtenstein and in Germany, so the Liechtenstein FMA, German BaFin, and specifically asked them, to have a look at the code and the constitution. And both have said that they don't consider that to be a security based on the evidence that they're seeing. I think it depends on the jurisdictions. I mean, some regulators are more open than others, and more, have a higher level of commitment when making those statements. European regulators, I think, tend to be quite good. So in both those cases, we've, gotten a positive approval that it's not, the native token Q is not a security. And constitution can help because that's where the rules are written down. Regulators tend to be much better at reading legal language than reading code. There are ways to gain confidence that what you're doing is not in conflict with any law or regulation.
And a sign that these constitutions are working is that there is a lot less litigation. The parties can resolve inside the DAO. They understand the rules and they will follow the rules when they have some kind of dispute. And without that, it's possible they might go to litigation. So no news is good news in that sense.
Any more questions?
Time
Comments?
for one more.
So I actually came in that is a bit late, so maybe you might have actually touched on this prior. But is it actually safe to say that a DAO can have a diverse set of various anchor jurisdictions, perhaps even that is across an international perspective? Let's say a DAO that actually works jurisdictionally within the Americas, and then say Europe, and then say parts of Africa, parts of actually East Asia. Like, how do you actually think about the construction of that kind of constitution as a function of that?
Yeah, I think we're going to have to cover that in a sidebar. That's a conversation to be had over multiple coffees or beers or whatever you fancy. But we have lots of crypto lawyers in the house that would be happy to talk to you about that.
Multi-jurisdictional entities already exist, and yeah, I mean, it is a process though, in current setup, but hopefully we can speed it up with two-click Cali.
Yep.
I think here the same principle applies, that just making things clear already is a big step. Thank you.
Thanks.
Thank you.
You have our contact details here. Come talk to us for further discussion. Thanks.